Mr. Pius Owioh Esq, you would agree with me that as the chairman of the Nigerian Bar Association Benin branch, you have a deep insight into the open justice system. We just want to find out from you, sir, what do you think from your experience are the impediments to accessing an open justice system?
My Lord, Honorable Justice Esoe Francis Ikone, immediate past Chief Judge of Edo State, and Comrade Austin Osakwe, and then the other panelist, Mr. Sawi, yes. My distinguished friends and colleagues. First of all, I have been asked a direct question, even if I have written down or penciled down something to, of course, read out. But let me start first of all by answering the question that has been put forward to me by Douglas Ogbankwa. I want to say very sincerely that I am in complete agreement with the points that have been adumbrated and identified by my Lord, the former Chief Judge of Edo State, in the keynote address. In fact, open justice was talked about, which of course gives room for open knowledge and open data. And you would quite agree with me that, like my Lord mentioned, that as much as possible, court proceedings are made, as much as possible, they are public, except in very few or restricted cases, like where, for instance, it has to do with a minor who has been violated and some other selected cases. And to a large extent, proceedings, the law itself makes trial to be made public. And when you get to be in court to conduct your matters, or you are a litigant, you realize that persons are not restricted from participating or being in the gallery to watch proceedings, except of course under the present COVID-19 experience, where a limited number of persons are allowed to access the courtroom, so as not to have the courtroom congested and therefore violate the COVID-19 restrictions or protocol. For those who want to access public records or documents of court like judgments and rulings, I'm also aware that when you apply, even when you are not a party to a proceedings, because these documents are public documents, you can get them. You apply and they give you certified true copy of the proceedings, rulings, or judgments of the court, or even documents that have been filed. You don't need to be a party to be able to get this record. And of course, it has even gone further. I'm sure it was introduced during the time of my Lord as Chief Judge, that judgments are even now placed in the website, in the judiciary website. You can get to access these documents judgments and rulings from the site. So, to a large extent, you see that the courts are doing so well. I mean, in terms of assessing documents and information from the court. Of course, my Lord did not spare time to discipline any person, particularly the magistrates of the lower bench, when they tried to restrict, place unnecessary restriction to members of the public, even when you want to apply for certified true copy of a charge sheet in the magistrate court. There are things that are open. Once you apply, you get there. And of course, we realize that in the course of making or trying to assess some of these documents, of course with payment of little stipends, I mean, you pay something to the revenue of the state, and then you are able to get these documents so long you have the information about, I mean, you have the particulars. For instance, the court that this document is filed, that it is pending, whether the document or the proceedings is still subsisting or pending, or it has been concluded. But again, we realize that much needs to be done, and that comes to mind, brings to mind the question that Mr. Ogbankwa has asked. How do we preserve these documents too, and what are the challenges that we have, particularly as practitioners who do business with the court? We realize that where proceedings have to do with matters that have been decided or that were initiated many years ago, maybe perhaps over 10, 15, 20 years. Because of the process of storage, it becomes a bit difficult to access these documents. In the archive, you are told at times that you have to spend as much as 3 weeks, 1 month trying to get documents, which of course have to do with matters that were filed over 15, 20 years ago. But we know that there is this, with the advent of technology, so much is being done, and we expect too that much be done to ensure that these documents and this information are kept and perhaps even stored or saved in the Google, so that over time, whenever you want to access this, this information can be translated and would, of course, be seen to have lived over a period of time and years for persons, even for generations that are yet unborn. They could be able to access some of these documents. But the major challenge that I believe the judiciary has is the area of funding. And this has been one area that has, of course, agitated our concern in our minds. And I'm glad that my Lord, the immediate past Chief Judge, has been in the front burner canvassing for financial autonomy for the judiciary. A situation where, of course, we continuously go cap in hand, begging the executive, is not the ideal thing at all. It, to a large extent, affects the workings of the court. If the court system is allowed to work in accordance with the law, particularly where the Constitution itself has already made provision for financial autonomy, and the President even took steps to further, of course, get what we call the presidential order or so to have this in place. I do not think that it is even necessary But he had gone ahead to do that. But of course, you and I know the frustration that has, of course, greeted this whole thing. Financial autonomy is a far cry. It is something that has not been implemented in any part of the country. There was a conspiracy among the governors to frustrate that. But again, I feel that it will require a government, particularly at federal level, a government that has the willpower to fight and ensure that this comes to play. But like I asked, and it continues to agitate my mind too, the judiciary too, we are the cause of our own problems. It does not take, it is the same court that would be invited to interpret and then give decision on a matter. And from the practice that I know, even in the Western world, we have a lot of lawyers who go out there to test provisions of the law and the Constitution. I know Mr. Douglas has canvassed has presented so many matters for, particularly that may look novel. And those two that will require the courts to give interpretation to. People started fighting to ensure that the Freedom of Information Act is in place. And of course, some courts are courageous, like my Lord did at the time. My Lord was the first judge who gave a considered determination of a matter that borders on the freedom of information. I was in the court when my Lord delivered a judgment in that direction. And I feel too that if practitioners courageously go to court, I know people like Mr. Austin Sakwe, who have always been in the vanguard to also ensure that the things work properly. You approach the court, get an interpretation of this. Why has government not done this? And where there's a pronouncement, and of course government is not satisfied, the matter goes on appeal, a matter that concerns you as a judiciary. I know that there is no court in Nigeria today that will decide against the already established financial autonomy for the judiciary. And this is a major setback for our judiciary. So I want to continuously urge and advocate that this being an area of a major challenge for against the workings of the courts, particularly with respect to getting things done in this direction, that something be done very urgently. If you like, call it conspiracy. Lawyers can move to court, get the courts to interpret, and then, of course, there's always a consequence for failure to do a particular thing. It was in this state that the Attorney General was, of course, sent to prison. So that will not, by the time one or two is taught a lesson, I am sure that those in government who know that they will not be there forever would learn their lessons. But again, and just on a final note, I want to say that, like my Lord has indicated, we do not need the state to domesticate the Freedom of Information Act, as it were. The doctrine of covering his field is sufficient for us. And of course, any court that says, oh, the state needs to pass this before it can be implemented here, of course, it's not been sincere and truthful. It's not living to its oath of office to respect and to apply the law to all manner of persons. And again, to say that we should, I know that we have little to say about the challenges that militate against getting information from the judiciary or from the court system. The focus, the attention should be even more, because with the other departments of government, the legislative arm and the executive arm, because they are the worst culprits. they make it difficult for people to access information because perhaps they have something to hide. But the judiciary has always lived up to its bidding. And I think we must encourage applaud the judiciary for doing just that. And then whatever limitations, particularly the area of finances that the judiciary suffers, we should try to ensure that we get it to be on board so that the courts would work very freely and then to the satisfaction, of course, of members of the public. Thank you so much.